right, we're going to get started. Hello, everyone. Welcome. My name is Mary Norrie, and I am the director of the Continuing Legal Education Program for the County Attorney's Office, of which we are an accredited provider. I'm going to get right to it today because we have 4 people who will be speaking, and we have a lot of material to cover. For all the attorneys who wish to receive CLE credit, make sure to stop by the back. Make sure you sign in, sign out. We can't issue any certificates of continuing legal education unless everybody signs in and out. Anyone else, please make sure you sign in. We have evaluation forms. If you haven't gotten one, please stop by and get one from Catherine. We'll collect them at the end of the program. I would like to point out that we will be recording this program. It's going to be used for future training purposes. And the presenters have asked me to just relay, if you could hold your questions until the end of their presentation, they would prefer that. And I'm going to now read their bios in no particular order. Susan Tokarski is Section Chief of our Litigation Bureau, Labor and Employment Unit. Susan has served as in-house counsel for all labor issues, working in close partnership with Human Resources Department. She consults and advises on compliance with statutory mandates, including EEO, ADA, FMLA, FLSA, and PESH, workplace violence complaints, and local ordinances. She assists in crisis intervention on issues involving disciplinary termination and collective bargaining, including matters concerning senior and administrative staff, as well as provides daily advice and assistance to all county departments, agencies, Human Resources, EEO, Labor Relations, and the Nassau County Civil Service Commission. Susan assisted in revising and updating the Nassau County policies, including EEO and FMLA. Sue serves as counsel to the Nassau County Indemnification Boards. Irene Velacci was appointed Deputy County Attorney in September of 2022 and assigned to the Office of Community Development. She was designated the county's Title VI coordinator in January of 2023. Prior to joining the county, Irene spent 32 years in private practice, concentrating in the areas of elder law, trusts and estates, guardianships, and residential real estate. She is past president of the Women's Bar Association of the State of New York and the Nassau County Women's Bar Association. She received a law degree from Hofstra University School of Law, her undergraduate degree from Malloy College, which is now Malloy University. Brian McLaughlin serves as the Nassau County Language Access Plan Coordinator. He was appointed as Deputy County Attorney in 2022 after spending 10 years in private practice, specializing in labor law defense litigation. He attended St. John's University Law School and earned his undergraduate degree at Notre Dame. Matthew Dwyer has served as the director of the Nassau County Office for the Physically Challenged since 2010. He is a member of the following committees: the Nassau County Adult Protective Services, MTA Accessible Transportation Committee, Nassau County Transportation Access and Accessibility Committee, Nassau County Senior Advisory Council, and the Nassau County Advisory Council for People with Disabilities. So we're going to get the ball rolling, and I'm going to call up Sue Tokarski. Please, everyone, help me welcome our presenters.
Good afternoon, everybody. I'm Susan Tokarski, and today we're giving you a presentation on 3 various programs, the laws and statutes that mandate that Nassau County, how to treat the public and the people that interact with us as in our official capacity as county employee. Some of these categories are also constitutionally protected, and it's important to realize that we have, as a county employee, we interact with the public at various different stages, whether it's somebody who comes to our counter, somebody that we meet in the buildings, somebody that is on county property. If we're acting in our official capacity, these are the laws that apply, and we must keep them in and abide by them and make sure that we are treating the public in a fair and equal manner. The first statute that we have is Title VI as amended, prohibits any person in the United States from being excluded on the ground of race, color, national origin, religion, sex, disability, age, income, or gender from participating in, denied benefits of, or subject to discrimination under any program or activity receiving financial assistance from the government. And it even goes beyond that, because Nassau County receives financial assistance in many different departments and in programs. We receive grants, we receive financial subsidies, we receive pass-through money. And to the point where when they look at it, it's not just if your program or your department receives financial assistance, it is now Nassau County that receives it. So regardless of whether or not your department receives it, all of Nassau County must adhere to these regulations and statutes. Title II of the ADA is a federal law that applies to public entities. There are 3 versions of Title II of the ADA. The first one being for public, that's Title I for public or employment. Title II is geared for municipalities, and Title III is the section that talks about large public spaces for corporations. They also must apply to and make things accessible to, applies to Nassau County, its departments and agencies, and it protects qualified individuals with disability from discrimination on the basis of disability in accessing services, programs, or activities. It also requires that Nassau County make all public property owned by Nassau County, any of our buildings, any of our workplaces, any of our streets, accessible to the public. So that means that we have to have wheelchair ramps on the corners of all your streets, to making sure that you can access buildings, access bathrooms, access entryway into the buildings, and also in the manner where we interact with the public. Some of our public, we're going to get into it in a little bit more detail, but that's what Title II of the ADA is. Then we're going to also be discussing with you the language access plan and policy. This ensures that persons with limited English proficiency have equal access to all benefits, programs, and services provided by the County of Nassau. It applies to anybody whose English is not their primary language, somebody who might speak broken English, somebody who might not understand English, and it also applies to somebody who is disabled who cannot speak English or not speak at all. See, I kind of forgot to. That was the introduction. The applicable statutes, as we described, are Title VI, that protects the protected race, color, national origin, sex, age, disability, and I think that's all here also. So all the protected categories is color, including intraracial discrimination. National origin includes limited English proficiency. National origin is even if somebody is from, it's not just saying somebody is Latin American, but it could be the differences between somebody who is Puerto Rican and somebody who's Mexico. That is considered national origin. So it's not just a race designation, but a country designation. Religion, sex includes sexual harassment, disability, age, and gender, and sexual orientation and gender identity were included in gender discrimination recently by the U.S. Supreme Court. And as we were talking before, who is subject to these laws? So since Nassau County receives federal financial assistance, the entire county must abide. Any program or activity within the county government must comply with these laws. Now, the county receives federal assistance in numerous ways. We receive it from federal grants to maintain our county roads. The police department might receive federal funds. Even if a county or agency receives what we call pass-through money from federal government to the state government. So every department and or agency of Nassau County must abide by these laws regardless of whether they receive the financial aid their department does. So that's the general gist of these laws, and now we're going to go specifically, and the next person up will be Irene, who will be discussing the Civil Rights Act of 1964, Title VI.
Thank you all for coming today. I also just want to give a thank you to my fellow coordinators and Sue, who has been our counsel since this all started as a team back in January, and to Judge Adams and Chief Hiller and the County Executive's Office and PR and IT and Mary Norrie and Kathleen Ramp. It has been a great effort, as anyone knows working here. It was a great effort, a lot of collaboration to get us to this day. This is a required training, not just because we're asking you to come and telling you you're required. This is required so that Nassau County stays within compliance of Title VI. It's mandated. Why? Because of the fact that we receive federal financial assistance. So regardless of whether it's DPW getting a grant for highways, or whether it's the department where I'm detailed, community development, getting the $17 million in grants that we just got signed off on from HUD for home and CDBG and ESG grants. Those are the pass-through grants to distribute to our partners in the county. Regardless, it wouldn't be just that DPW only is subject to this, or that OCD only is subject to this. By the fact that the County of Nassau is a recipient, whether it's even if it's only to a particular department or agency, we are all mandated under compliance. And there's a lot of record keeping that we have to do, and one of those being to have this training. Just so you know, we're recording it in the hopes that HR will be able to use it and add it to the stockpile of all the other required trainings that we do take for all the employees that are here, that are not here. Of course, we couldn't have all of the employees in one spot, but we really greatly appreciate our colleagues from the County Attorney's Office and all of you who are department heads, agency, and the reps. Even those reps who just found out that they're reps and that are here today, we really appreciate it. That being said, I also want to point out a little bit of housekeeping, because again, it falls under my umbrella title as Title VI Coordinator. Keeping our records for compliance is really important. So there was a department reps list that there's a few going around today. It was also emailed to you in your materials. please make certain that you look at that for your department. If there is someone on that list who is no longer in your department, or you're now taking their place permanently, please make sure that you email me that person's contact and info. We're under an obligation as part of our federal compliance to maintain an active department reps list with accurate contact information. It's also going to be the point of contact that when complaint forms come into me or resolution requests go into Matt or to Brian for ADA or language access, that we're going to need the name and contact of your rep who is going to be aware of the investigation and might have the right to be part of an interview and an investigation with the county's investigators. So that's really key to that. In addition to it, I believe also Matt can highlight it later, but as part of his ADA manual, he has to have an accurate list. So that's why I'll harp on that a bit. The other thing also that was in your materials, thanks to IT and PR, it's in many ways of accessing on the county website, is our public notice that is in both English and Spanish. There's a few floating out there today. I ask you to please, not encourage, but please do, make certain that in the entranceways and the reception areas of your buildings, of your offices, of your agency departments, that you have these posted. Again, federal mandate. What's important to note about Title VI is that I think in the past it was a misnomer that it's just about residents. No. Title VI, Title II, LAP violations all come under for anyone who walks through, drives through, enters Nassau County property, encounters Nassau County employees who feels in some way that they've been discriminated against. So make certain that you have the public notices. We emailed them to everybody. There's some floating around. You can access them from the county website as well. Please post them, doorways, reception areas, whether you have a building, whether you have a small department of 3 people, or whether you have several buildings of 1,000. Make sure that they're posted so that we stay in compliance. Also, the complaint and resolution forms, we'll talk more about that later, but those are all accessible online. We also gave you the hard copies. They were emailed to you. There's a few floating around as extras today also, that no matter how you encounter a person from the public that feels that they have been discriminated against in some way, you have it at your fingertips. It's not always going to be easily accessible for someone to fill out the fillables form on the website. So that you have it, you pass it on. Make sure you have those handy as well. We also ask, take this back to your employees. This is something that as department heads and reps, it's not just for you to keep on your desks if and when it happens. Yes, there's going to be the recording available to them, but this is something that we have to keep a constant conversation about. That being said, we are still on the right one. Okay. So as far as keep in mind the word compliance, because that's what it's all about. The federal government has given the County of Nassau grants in many ways, whether we're to distribute that as pass-through to other agencies within the county, or whether it's for our own use for county improvement throughout the county. We have to consider the word compliance. And they are looking to see our ways that where there might be a violation, where somebody might actually have been discriminated against. What have we done? What do we do? What is our process for making certain that we remediate that it doesn't happen again? And that is how the federal government wants us to think about this. Keep in mind that the county, when they talk about it, like I said, is all of us. So the county is the recipient of a grant. We are the recipients of the grant as the employees. Also keep in mind, this comes up every minute of our day at community development. We are partners with our CDBG consortium members. Those are villages, towns, the 2 cities in Nassau County. Our contracts, because we have federal contracts with HUD, our contracts already say that our subcontractors, our sub-recipients, whether you're a village or whether you're a nonprofit who's looking to access these grants, they all have the language as far as there shall be no Title VI discrimination and who the protected classes are. So our sub-recipients know that. They know when they sign a contract with it that that's part of our monitoring at community development. So those of you who do have similar situations with sub-recipients of grant funds, make sure you look at your contracts that they're in there. Okay. There it goes. Okay. Title VI protection. So Sue already talked about the Title VI protective classes. And the statutory provision is right out of the Civil Rights Act of 1964. It's been amended so many different times in the 70s and right up until recently by state, by federal law, and by case law. And when you break it up, think about it. No person in the U.S., any member of the public coming in to see any of us on the ground of race, color, national origin shall be excluded from participation in any program or activity, shall be denied benefits of any program or activity, or be subjected to discrimination under any program or activity. And as amended, they've added on through state law, through case law recently, with the Bostock case with the U.S. Supreme Court. You have religion, sex, including sexual harassment, disability, age, all ages, income, and gender now including, as per state law, sexual orientation and gender identity. The bottom line is every member of the public that we encounter is in a protective class. So in order to avoid claims, whether they're legitimate or not legitimate, okay, not every claim is going to be valid, but it's important, and I think everybody I know here is mindful of it. Our actions, our words, our manners, our tone, we are all under an obligation here to the public to be in compliance. So even if it's somebody asking you the same question for the 1,000th time of the day, how you react to that person, depending on that person's sensitivity to their own needs and their place in life, they're going to perceive how you are reacting to them and why. So think of that, whether what you are doing might or might not be in compliance. Everything we do as county employees has to be in check. What does Title VIII prohibit? Any of the following based on race, color, national origin, religion, sex, disability, age, or gender. What does it prohibit? If we deny an individual a disposition, a determination, a service or a benefit. If we deny an individual their being among others where they're segregated or receiving separate treatment. By applying a difference in admission, enrollment, or eligibility standards or requirements. By denying that person participation if they already are a member of a planning or advisory board, which is an integral part of the program that's being administered. it prohibits us from selecting a site or location with the purpose or effect of discriminating. And it prohibits us from using disparaging language and or comments regarding someone's protected class. Now, getting to age. Here we go. It was age. I turned it off tonight. No. There you go. Okay. Age discrimination. So you're going to hear Sue say it. We'll say it again at the end, and at the end, and again, and again, and again. Anything that has to do with employee to employee, not Title VI, not Title II, not language access. We know that that goes over to Mary Elizabeth Osterman. Okay, employee to employee, that's where it goes. Director to programs coordinator goes over to EEO, that we know. Age discrimination, there are two acts. One applies to Title VI, one does not. You have the Age Discrimination Act. That is a protection that is covered under Title VI. And that's where no person, regardless of your age, so it can be an 8-year-old or an 80-year-old, can be excluded from participation in or be denied benefits or subjected to discrimination under any program where we are a federal financial beneficiary. So it protects all ages that we encounter. That's different from the Age Discrimination and Employment Act. That has to do with employment issues specifically, not Title VI, and that's where it protects an individual who is 40 years of age or older from employment discrimination. Okay, so make sure you understand that difference. So Nassau County cannot discriminate against the delivery of services regardless of age, of any age. In cases like this, the courts apply a different standard with age discrimination than it does with the other protected classes. With the other protected classes, the standard that's going to be applied is whether there is a compelling good standard for having acted as to this particular protected class. That's different in age discrimination. In age discrimination, the standard that will be applied is the rational basis standard. So again, it's comply, comply, comply. As long as a federally assisted program can provide a rationale for distinguishing the delivery of services based on age, that the county complies. So an example, programs that are funded by the federal government that focus on the needs of juveniles are not discriminatory based on age if there's a reason for limiting the age group. So where you have a program that's geared towards young people who are of a particular educational or psychological development stage, that's considered rational, that's considered in compliance. Okay, and I thank you, and I'm going to pass this on now to Brian, who's going to talk to you about language access.
Hi, I'm Brian McLaughlin, and being firmly monolingual, I was the obvious choice to serve the county as the language access coordinator. So you're going to see the terms LAP and LEP being used interchangeably. Some municipalities refer to it as LEP, some refer to it as LAP. They really are two terms that refer to two aspects of the same thing. LEP refers to limited English proficiency, which are the people that this program is intended to serve. LAP is the plan itself, which is the language access plan. So the language access plan just ensures that anyone that is of limited English proficiency is still able to access all the same programs, services, and activities that the county administers. We're just trying to ensure that someone's inability or lack of proficiency with the English language is not a bar to them accessing anything with the county. And so while the term language access plan sounds like this large apparatus, in practice, it really comes down to two simple solutions, which is either A, getting a county employee who is a certified interpreter and can speak with someone who is not proficient in English, or the more common solution in various settings, which will be the language line program, which is a company that the county has a contract with. It's essentially a hotline that has on-call interpreters for a number of languages, including sign language. So what we're trying to do is to prevent language discrimination, which means that we have to be able to make sure that everyone has meaningful access to county programs, regardless of how well they speak English. Now, the bullet points you'll see here, these assessment steps, have essentially already been made for Nassau County. It's been firmly established that Nassau County is a multilingual county. In fact, does anyone happen to know what the top 6 non-English language spoken in Nassau County are? We're going to do some group participation. Everyone's got to earn their CLE credits today. So, number 1, obviously, oh, go ahead. Yep. Creole is, yep. Farsi, correct. Chinese and Korean. So it's Spanish, Italian, Farsi, Creole, Chinese, and Korean. Oh, I'm sorry. Sorry. No, it's Farsi. Yeah. So those are just the top 6. Obviously, there's many more languages spoken within the county. So the actual language assistance services are, like I said, the language line. So this is the hotline that you can use anytime to get a hold of an interpreter for almost any language. If you're asking for an interpreter of a more specific, less common language, there may be a bit of a wait, but you will be able to get an interpreter. So the number there, which we've given in your materials, but it's the number you need to know, 866-874-3972. That is your hotline to get a hold of any type of interpreter. They also, now a lot of these interpretation services are offered over the phone, but obviously they have video conferencing technology, which is obviously going to come in handy for people who are hearing impaired or people that need sign language interpretation services. They also provide document translation services, which is, of course, is of utmost importance, because another part of this, aside from just interacting with ourselves as county employees, these people also are entitled to translated documents that they would get from the county. And so while we often have some Spanish language versions of our county documents on hand, obviously we don't have every county document translated into every language. Language Line can provide that service. If you are going to offer direct oral language interpretation by a county employee, that employee has to be interpreted for this to be in proper has to be certified in order for this to be in proper compliance with the language access plan. While someone may be fluent in the language, may remember a lot from college, if they're not a certified interpretation, we can't say that we're being in compliance. So that brings us to what is not meaningful access. Now, there is the strong inclination, and I feel it myself, when you're dealing with someone who's speaking a different language, but they have some English, you have some Spanish, maybe you can get a hold of, the main gist of what they're going for. You can try and offer them help directly. It's a well-intentioned, good faith effort, but the risk you run, especially when you're working in your official capacity as a county employee, and you're intending to provide this person with a county service, is you run the risk of something being literally lost in translation, and that person is either getting wrong information or their issue is not being addressed at all. So, for example, when you're just trying to get through an interaction with a member of the public who does not speak English, and you're going through with broken English and hand signals and gestures and things, you're not really providing proper county service to someone of limited language proficiency. The same thing is if they bring someone in who says that they can interpret for them, a family member or something. If that person's not a certified translator, not a certified interpreter, we don't know how well their English skills are. We don't know how well their translation skills are. So again, we can't ensure compliance if that person, even if that person's a family member who's offering to help out. Again, if someone comes in and is requesting a document and we know that they have limited English proficiency, it's not in proper compliance to just give them the English language form of the document and tell them that they can find someone else to translate it. We have the resources now in order to get them a translated copy, and so we're under an obligation to do that. Finally, this will cross over with what Matt's going to talk about, but if someone is hearing impaired, we have now resources in order to get them sign language interpretation services, video conferencing that can help them communicate with the county and access county services. And so we're under an obligation to do that. So finally, the two main aspects that you have to worry about in terms of ensuring compliance with the language access plan is, again, the language line service, which is going to be where a lot of your solutions are found. And if you happen to know of county employees that work in your department or someone you can get a hold of that is a certified interpreter in a given language, you can use that employee. But again, only if they are certified as an interpreter. And that'll bring up Matt Dwyer.
Hi, my name is Matt Dwyer. I'm the director of the Office for the Physically Challenged. I was going to tell a lawyer joke, but there's way too many ears in the room here. I wouldn't make it to the back. I've never done this before, so. We're going to talk about a lot of things today as it relates to the Americans with Disabilities Act and Title II of the Americans with Disabilities Act specifically. Let me figure out how to do this. So, Section 504, which Sue talked about, and Title II of the Americans with Disabilities Act, are really the scope of our discussion. Definition of a disability under the Americans with Disabilities Act is a physical or mental impairment that substantially limits one or more of major life activities such as walking, breathing, seeing, hearing. It also includes a record of such impairment. The person doesn't necessarily have to state it. If there's a record of it, or if that person is regarded as having such an impairment of a disability, that's good enough to qualify them under this act. Title II applies to state and local government programs, all of them, without exception. Examples being recreational activities, social services, voting, emergency services, offices where people visit, whether they're renewing a license, applying for food stamps, paying their taxes, attending a county meeting, whether they serve on a board or commission, or conduct government business and participate in public meetings. Specific requirements of Title II, an example of which is state and local governments must communicate with people with disabilities in an effective manner, as Brian spoke of, to make reasonable modifications to policies and practices where needed to ensure that a person with a disability can access state and local government programs, services, and activities. To allow service animals to be with their person even if there is a no pets policy, and we're going to speak more about that later. To provide program access by ensuring that individuals with disabilities are not excluded from programs because of existing building or facilities that are inaccessible to them. Follow specific standards for physical accessibility when building or altering a building that's new or old, and to follow specific requirements for ticket sales and testing accommodations, which is a very interesting thing, and we get a lot of inquiries along those lines. The ADA requirements for service animals, and you'll see you'll see people with presenting their animals as service animals everywhere, restaurants, movies, drugstores, and in buildings. Oftentimes, people are not willing to question that individual, even though they may be suspect that that is not a service animal. There are very strict requirements for a service animal. Only dogs and miniature horses are recognized as service animals under Title II and Title III of the Americans with Disabilities Act. I doubt you're going to see a miniature horse in Nassau County. There's one in Suffolk that I'm aware of. Monkeys are actually considered service animals, but they are not allowed out in public. We had a request to bring a monkey to one of our parks and pools a couple of years ago, and the facility that trains the monkeys in Massachusetts was appalled that this individual would even try to do it because of health laws for the most part, but also they just don't have the control that you might have over a dog. So you're not going to see a miniature horse. If you do, let me know. A service animal is a dog that is individually trained to do work or perform tasks for a person with a disability. Generally, Title II and Title III entities must permit service animals to accompany people with disabilities in all areas where members of the public are allowed to go. Now, later on, if you have any questions about the difference between a service animal and an emotional support animal, don't hesitate to ask. I'd be happy to share it with you. How a service animal is defined. Service animals are defined as dogs that are individually trained to do work or perform a task for a person with a disability. Examples of such tasks include guiding a person who is blind, alerting people who are deaf, excuse me, pulling a wheelchair, alerting or protecting a person who is having a seizure, reminding a person with a mental illness to take prescribed medicine, calming a person with post-traumatic stress disorder during an anxiety attack, or performing other duties. Service animals are working animals, not pets. The work that a dog has been trained to do must be directly related to the person's disability. Dogs whose sole function is to provide comfort or emotional support do not qualify as a service animal. The big thing is how to address an individual that may come into your facility with an animal, and you're allowed to ask two very basic questions. Is this animal, dog, required because of a disability? If the answer is yes, you may say, what task or specific duty is this animal trained to do? Staff cannot ask a person about the person's disability, require medical documentation, require a special identification card or training documentation for the dog, or ask the dog to demonstrate its ability to perform the work or task. And that's really where we get in trouble sometimes. You probably see people out in parks and restaurants with a little pocket poodle with a vest on, you know, running around a park where there are no pets policies. You can buy those online for anywhere from $50 to $150. They mean nothing. Many people will have a vest on with a legitimate, a legitimate animal, but the majority of them are bogus. And it's important to be aware of that. Sometimes people are afraid to ask the individual because they don't want to either offend them or say the wrong thing. So the two questions you can ask: is this a service animal, and what task does it perform? So, where are service animals allowed? Service animals are an extension of the human being. They are allowed virtually everywhere that a human might be, with rare exceptions, such as a hospital operating room, or a burn unit, or a place where they may cause an undue commotion. But overall, they're allowed just about anywhere an individual is. Perfect example is someone has a service animal in a restaurant, and someone comes in and says, "I'm allergic to dogs. Can you please have them move?" The answer is no. The individual who might be allergic to dogs is going to be asked to move to another table, but the person with the service animal certainly can remain where they are. What what is effective communication under the ADA? And this goes back to Brian and some of the things that he's had to say. Nassau County must ensure that its communications with people with disabilities are as effective as its communication with others. The county is required to provide appropriate auxiliary aids and services when necessary to ensure effective communication. Primary consideration must be given to the choice of auxiliary aid requested by the person with the disability. Whatever accommodation is requested, the county must seek to provide it unless it is determined to result in either a fundamental alteration in programs and services or an undue financial hardship or administrative burden. Examples of auxiliary aids and services include, for the deaf or hearing impaired, American Sign Language interpreters, note takers, real-time captioning, real-time captioning of written material, assistive listening devices, open or closed captioning, TTYs, and an exchange of written notes with the communication when the communication is not complex. And that's, comes into play with like a police officer or anybody else where a person is hard of hearing or deaf. Best way to do it if they speak English is to hand them a pad and paper. See if you can get the communication online. They may have a request for an interpreter, but again, if you give them the pad and paper, it makes it a little bit easier. People that are blind or low vision, qualified readers, audio tape, braille, large print material, audio descriptions of PowerPoint or video presentations, and assistance in locating items. Speech disability, speech impairment, relay calls, computer terminals, take turns typing back and forth, which is really what the relay calls are about. I don't know if anyone's ever used it, but it's a very effective cut and dry way of communicating with an individual with disability. So a lot of people will say, what do you do in the office for the physically challenged? And aside from our administrative role of the 100,000 accessible parking permits that we hand out each year, my answer often is that I step on people's toes in a very polite way. Not because Matt Dwyer says you have to do it this way, but the law says it. And it's really to protect the county and to advocate for those with disabilities. So it's kind of a double-edged sword, but we try to do it. We try to do it effectively. And I'm going to turn it back to Sue, I think. Is that correct? Thank you.
And one of the other ways that I just want to discuss about effective communication under the ADA, it's one of the things that Nassau County has worked on. Our website, and that is one of the issues that always comes up with effective communication under the ADA, is making sure that the websites are. I will tell you that our IT department has worked very hard, and the Nassau County website has a tab labeled accessibility, and it is advised that the website is compatible with a PDF reader and other accessibility information to make it more accessible for the public so that they can use our websites. The county website does have a lot of information for people, whether it's about programs in parks, about applying for benefits. The website is provides accessibility. We've gone by over a lot of information for you regarding protected categories and what the law considers. Does anybody have any questions about that we can present to our panel? Anything about Title VI? Because these laws, you have to understand the protected categories, and also or any scenarios that might say, before we get into the procedures of how people might come in, we wanted to give an opportunity at this time for anybody to ask any questions. Yes, can I? let me repeat that question for everybody in the room. The question is, if somebody comes in and appears to be having problems, or it appears that that person's primary language is not English, and or they have limited English ability, do we have an obligation to accommodate them?
I mean, if you're truly concerned that in your interaction with them, they don't seem to be fully proficient in the English language, then I would say yes, you should call on the language line to ensure that you're having proper interpretation.
Try this one.
Oh,
Try this
now it's on. There we go. All right. So what I was saying is that if you truly believe that there is a lack of proficiency in this person's English skills when you're speaking with them, then it is always the best move to contact Language Line, see if you can get an interpreter, just because that way you're ensuring that there is no miscommunication, that you are certainly in compliance. Now, it can be that you are able to effectively help this person regardless of whatever shortcomings they have in using the English language. And so it may end up being that they don't file any sort of complaint, which means that for all intents and purposes, we escape any problems in terms of consequences of lack of compliance. But if you truly have a belief that they are not being fully proficient in communicating with you, then yes, you do have an obligation to ensure that compliance by contacting Language Line.
Yes?
How accessible is an interpreter? In other words, we call the hotline, couldn't say that we use a particular language interpreter, a certified interpreter. What if, just asking, we need someone who speaks Chinese or a particular.
So your question is, if you contact Language Line, you need a specific type of interpretation, you know, how able are they going to be able to speedily respond?
If a person in front of you, you know that you need a language interpreter, and you don't want to send that person away and say you got to come back another day because you got to get an interpreter.
So this is the only thing that Language Line does, and so in my experience with them, they have been incredibly responsive in terms of getting any type of interpreter you can ask for. Now, you can get as specific as you want. I had once an incident where I needed an interpreter that was proficient in specifically a Moroccan dialect of, I forget exactly how it was a language I had never heard of really. And we were able to get one, and then that person had to leave, and then we were able to find another one almost immediately. And so, I mean, that's part of the benefit of being this close to New York City. There are no shortage of interpreters, and this is a service that is able to find them pretty immediately. And so I haven't encountered a problem with that.
Any other questions? Yes?
Emergency management, if we have an activation for a storm or a major emergency, we call on Hispanic Affairs or Asian American Affairs to send people over to help us in case we get phone calls. Is that not good anymore?
His question is, in an emergency situation, they call Hispanic Services and Asian Affairs to assist. Is that sufficient, or?
So you're asking, in an emergency situation, are you still obligated to get Language Line?
Say there's a hurricane coming, we know it's coming.
So they call Hispanic
We call
Affairs.
those two departments to have people assist us. Is that not efficient anymore, sufficient anymore?
Well, I believe getting those departments to assist you is obviously a step you should still take. I don't know if I can give a proper answer on how to get an emergency response out through this program. I would have to look into that further for you. I don't have that information in front of me.
But we do have, but just so that you're aware that those two departments do not give you complete, as Brian indicated that there were in Nassau County, the 6 languages. I don't know if they would be able to provide you with all 6 languages.
No, they can provide 4 of them.
Okay, so then that's close.
Instead of, if there's an emergency, someone calls up, where's the evacuation routes? I don't wanna put somebody on hold, and whereas if I have Hispanic Affairs there, why can't they?
Oh, they can answer. It's just for those other languages where you don't have somebody present to assist them. So if you have somebody who they can't provide you an interpreter with, you would have to seek.
What if they're not certified? That's my concern. If they're not certified. But they're fluent in Spanish and English.
If they're, by certified, really what we're talking about is if they are, our civil service employees that are bilingual. Those languages in an emergency situation, it's different than, say, the individual that is coming into the clerk's office, you know, to file papers. It's a little different. You have a little different time period. So as long as that person that is giving that information can assure you that they are confident enough to provide that information in the other language. In an emergency situation, there are exceptions to every rule, and when they are looking at them on a legal point of view, with actions or anything later on, those are taken into consideration. How much time did we really have to get that information out? What resources did we put into it? How fast were we able to communicate? And if somebody was truly struggling, could we offer them the language line? Okay, and yes?
A question under the Americans with Disabilities Act. Is a local government or municipality required to convert a child's playground to ADA compliant?
The question was, are we required to convert pursuant to the ADA, convert a playground so that it is ADA compliant?
Generally speaking, yes. Again, if there are multiple playgrounds, you know, maybe some features of that playground should be accessible. It's not always reasonable to convert an entire playground where there's sand and wood chips or anything else that might be the surface into a compliant playground setting. So it's kind of like if you have beach access and you have 24 accessible blocks on a beach. Not every one of them has to have Moby mats down to the ocean. There's a certain amount, percentage, I think it's 25%, depending on how many you have. So, you know, again, they have to make a good faith effort, you know.
Yes. The question is whether or not people are not necessarily certified. Can they use people who are bilingual to assist the public?
A bilingual employee can certainly assist the public, but once you reach that point at which there is an obvious barrier between that person's proficiency with the language and the member of the public's proficiency with English, then you have to contact Language Line in order to ensure compliance. Well, the judgment would have to be, you would have to start with the employee themselves, and that's why, you know, when we're going to get into reporting of incidences later, it has to start with the actual employee that has the interaction. If that employee believes that they're communicating with this person properly, then obviously there's not going to be an issue. The minute there's a moment in the interaction with the member of the public where a word is understood, a phrase is understood, or something is misunderstood by the member of the public, that should be the indication that further language assistance is necessary.
And I think also taking that into consideration is not necessarily just also the proficiency, but what you're trying to communicate to the person. Are you communicating whether or not an event is on Friday night, or are we talking about a more serious right for the individual, something more important for that individual, such as whether or not it's social services? Are they getting their rights? Are they getting their, how much of protection of their rights are we looking at? So it's a balancing, as Brian says, a lot of things. What are we looking to provide that person? What information? And whether or not the your translator feels confident in giving that information, and how much that person is can understand, of how much they feel that that person is understanding. But if the person is asking every other minute, explain to me again, maybe they need to go to a more proficient translator. Yes, can I help? One of the questions is, how do we deal with somebody who has under gender identity, when we're talking about people who may present themselves one way, however their ID might indicate another. Usually when you have somebody of that nature, you look at and maybe ask them, how do they want to be addressed? Do they want to be addressed, the new thing is to be addressed, or common practice is now the terminology of they as opposed to he and she. Sometimes it's a little confusing the older you are, because you have it drummed into you from grammar school that they means more than one. However, but that is now the more common and acceptable terminology to use. But actually you go by that person's preference. That is what I believe the statutes and the case law does state. Yes.
Back to the service animals presentation. The village where I live, this is express prohibition on harboring certain type of fowl or animals on your property. So can you explain the difference between a therapeutic animal and a service animal? I know somebody sounds foolish, but
No,
they wanted to have goats on their property. The village where I live doesn't allow that, so they claim the therapeutic need, not that the need is foolish, but how do you keep an animal like that on your property versus?
first thing I'll say is there is an enormous amount of abuse. And people will try to get around the laws every day. Okay, so the ADA, again, the only service animals recognized are dogs, miniature horses, and monkeys that are restricted to home use. Under the Fair Housing Act, they are much more lenient with regard to what we call them, emotional support animals. Under Fair Housing law, you may have a building that is a no pets policy, but they can have an emotional support animal. Now, they still have to comport with all standards of good behavior. And if there's a requirement for licensing, if there's a requirement for vaccinations, that all has to be in place. You know, if you have a chicken or a rooster that's going off every morning at 5:30, that's not going to work. The goat too, you know, there may be, is this goat, it's an emotional support animal, where's the goat living? You know?
That's the issue. That's what the person's claiming to do where I live, that they want to go for emotional need, of course, but this code is very specific, and then there are a lot of issues that go along with having an animal like that on your property.
Right, and a service animal. I'm going to go back to it because it all evolves around that. That animal is supposed to be with the individual at all times. Somebody comes into your restaurant and they say, well, this is a service animal, but it's with the girlfriend, not the gentleman that has an issue, a disability. That doesn't work. You know, emotional support animals are housed in a home, not in a yard, not in a fenced-in area in the backyard or in the garage or anything of that nature. They need to be with that individual, but providing that service to the individual. And again, emotional support animals are not allowed out in restaurants, bars, movie theaters, and things of that nature. And again, check the licensing regulations and vaccination regulations that might exist.
And Matt, just to reiterate what you said, they have to be dogs if they're emotional support.
No, emotional support animals, you can have a pelican, you can have a snake, you can have goldfish, which generally aren't a problem,
But they're not service animals.
they're not service animals, no.
Okay. Rich?
Yeah, so I know that lenders at the end of a loan transaction, when money to borrowers, will have the borrower sign an acknowledgement that says the lending institution has violated their ADA rights or discriminated against them. Can an accounting department have a document where at the end of an interaction with a constituent, they acknowledge that they don't think they've been discriminated against or violated their ADA rights?
That's a really good.
I don't
Kinda
know
given.
necessarily how enforceable that would be if it's a primary form. Usually waivers of your rights would require a little bit more specificity, and also, is it just that you're,
It's not a waiver, it's an acknowledgement that you don't believe that you're discriminated.
but even still, it has to be more specific, and it really, in general, you can't waive away on your on any of your protected rights. You really cannot just waive generally. There has to be something that you're looking for in a specific transaction.
Rich, I would steer away from any of that, just from what I know we have to comply with at community development with our HUD contracts. We've gone as far because HUD looks to it to make sure that everything possible has been disclosed to the recipient who is the first-time home buyer under the first-time home buyer program, but it cannot be a waiver. So, HUD will want to see that they're signing an acknowledgement that they've read the program guidelines and they've received the program guidelines. And in the program guidelines, it's the onus is on the county, or the onus is on whoever our partner is, whether that's the housing partnership or CDC or whomever it might be, that, we don't discriminate, and we have our Title VI clauses in our contract, and we have our Title III clauses in our contracts that our subrecipients sign. But to sign a waiver saying they acknowledge that, that is something that we would not, in our department, put that in. I would say that would be a red flag to HUD.
Yes. Just so that there is two things I want to just raise, is that one, there shouldn't be anybody taking pictures in a locker room, regardless of what gender and whether it's the same sex, different sex, or anything. So just to put that out there, there's even a law that says that as an employer, we cannot take pictures of or monitor employee locker rooms. So we'll start off with that statement. And if you have somebody lingering in any area, that it might be something that you might want to call public security to come in, escort somebody out. Just as you wouldn't want to have, like I said, you wouldn't want to have somebody lingering in a locker room, whether it's the same sex or not. You know, the locker rooms are for changing and leaving. So, with the school districts, they're subject to different laws and rules. Part of that is under Title IX, which is specific to schools and under the educational laws. So they have a little bit different. There are a lot of opinions that have come out on that issue. So I'm not going to address an answer, but they are a little different. They have come up with a little different on the rules on that.
So posting something in that room or in the facility that no cameras, no picture taking is allowed. You know, that's the first step.
And
No
also,
loitering.
Yeah, and even there should not be loitering there. So if they believe that there is a man, as opposed to a student, because the student, and that's really where we're getting into the interest that I don't want to necessarily address, because there has been a lot of opinions under Title IX regarding gender identity issues with the sports in education. So with that, I'm not going to address it, but I think that you do have to look at, even for county facilities, if you have somebody who says, I am, there's also a lot of now, any single bathroom is really gender neutral, so there's no such thing as a single male bathroom or a single female bathroom, so there are those issues. I didn't answer your question.
We can't.
It's about how we communicate and how we respond to anybody that's in a protected category.
Right.
Because it's not, discrimination comes up in many different ways, whether we prohibit somebody from doing something, whether or not we put them further. So it's more broader than just communication. Communication was one aspect of this. We have the disability, whether or not we accommodating somebody with a disability. And under Title VII, discrimination is a larger aspect, whether or not we're, as the list that Irene gave about different ways that we act and interact with people of different nationalities, different races, different religions, and how we treat them and how we accommodate them.
Tom.
Yes, Tom? That'll be the last question. We have more to go.
To what extent does left and lab apply to county employees and contractors, vendors that the county
So the question is if LEP and LAP apply to county contractors and businesses. So are you talking about if there's an obligation to translate a contract, the written contract?
Well, the contract interaction with workers or work in the county facility.
Yeah, if you're having interactions with contractors, with actual employees, and there's a language barrier there, then yes, you have to access language line in order to get interpretation services.
Or deal with somebody who is bilingual to deal with them. Okay.
Can we add to that? You brought up a very important subject, contractors. Anybody that the county has representing them, whether it's another organization, where we subcontract work out, whether it's youth services, seniors, parks and recreation, they are compelled to follow Title II, including language access. And that doesn't mean that they're aware of it. It means that they follow it. We get an enormous amount of inquiries along those lines. That facility, if they have a facility, that facility must be accessible. If they're providing services that we're paying for, that facility must be accessible.
Tom, it's the same thing you've seen community development's vast portal, that when any of our subrecipients apply and they have their contractors and their developers, there's so much that they have to sign besides what the county requires. There's so much they have to sign that HUD looks to. So as for federal financial assistance, that's all got to be communicated, when you take on the contractors and the developers.
Okay, we're going to go into the next provision of our thing and our presentation, and that's on no retaliation. All three programs, Title VI, ADA Title II, and the language access, all have programs that have what we call a no retaliation clause. No county employee shall take any adverse action against someone for opposing any act or practice of discrimination, or because that individual made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing. These statutes are designed to protect, the retaliation provisions are designed to protect the complainants, family members, and advocates. It protects anyone who can be considered to have supported the rights of the protected classification of covered in the legislation. This could be, as I said, a family member, somebody who says, you know what, that I was sitting with my Aunt Mary and they weren't explaining to Aunt Mary enough about the program or why she couldn't get something, or something of that nature. Could be that was present, or it could be another county employee. It could be an advocate, somebody else online that said, hey, don't talk to him that way, or was aghast that somebody said a disparaging remark, or was frustrated with somebody because they didn't speak English. Somebody who walked away and said, I can't believe it, I have to explain everything to this person 10 times because they don't say English. We do get complaints of that nature. And that is what these seminars are designed to say. You can't do that. But also, if there is somebody else, and they protect, if this person has a reasonable good faith that the action complained of was in violation of the relevant statute, that person is protected under the no retaliation provision. The retaliatory activity that we can't take a retaliatory activity. In other words, if the person themselves complained, my caseworker or the person looking at my application was mean to me, if we take that person's complaint, and it really wasn't a matter of being mean, it was somebody trying to be efficient, but if that person had a reasonable belief, that action, a reasonable good faith belief that the action they're complaining was true discrimination of some form, they are protected. And what are they protected from? That the adverse action if they suffered an adverse action that would dissuade them from someone supporting a charge of discrimination. And the examples could be somebody being harassed, somebody, if it was an employee who complained about something, if they were demoted or switched, or they're transferred to another area, or if, because I complained about you, my application all of a sudden got put, I was the next person to be served, and my application now gets put further down in the pile, and now I have to wait an extra 2 months. That's retaliation. Putting somebody further back. So these are all fact intensive, because really what we're looking for, who was the person? Did they take a protected activity? Did they make an actual complaint? Did the person have a good faith belief that they had an actual complaint? Did they have, and did they suffer an adverse action? So if retaliation is found, the individual can commence an action for damages, or the overseeing federal agency can commence a proceeding to suspend, terminate, or refuse to grant financial assistance, or the complaint can be referred to the U.S. Department of Justice for judicial intervention, whereas the county then would be sued by the federal government. So it's very important that we keep these in mind, that more times than not will be found not to have discriminated against somebody, but the county does get sued and is found more often than not on discrimination cases for retaliation, because somebody got tired of helping somebody. Somebody got tired of taking that extra step, or when somebody did do that, they were frustrated, they said something in anger, or they took somebody's, just complained to them too much, denied them their services, made their services wait, putting them, like I said, putting them on the bottom of the list. So there are a lot of things. So it's not only to remember at all times that the county itself has to take the extra step in helping these individuals, but also not performing any retaliation. The next thing that we're going to talk to you about is our next step of the program is, how does the county enforce these laws? And there are 3 different ways, although it's 3 different programs, we have to look at, and really the procedures are to determine what are the goals of that specific program. Are we going out of our way providing services for that person, taking that a little something extra for them, or are we remedying behavior that was in violation of these statutes? So Irene is going to talk about her program, then Brian, and then Matt. You can stay there.
That's fine. Is this on? Yeah, you can hear me. Okay. So it's not going to be unusual. It's happened already where Title VI kind of seems to be the umbrella, right? Because it covers all of the protected classes. But so there'll be times when it's going to overlap, that if I get word of a complaint, if I get a complaint, it might be a situation where, well, this has to do with that there wasn't a cut on county property for wheelchair accessibility. That's going to get passed on. I would defer to Matt. There's going to be something where with language access, where someone feels that they were discriminated against because they had a difficulty with a county employee because they couldn't communicate properly, and maybe they weren't treated in a proper manner, or alleged to have not been treated in a proper manner based on their ethnic origin, because they didn't have proper communication. That might get directed towards Brian. What has happened a lot in just under a year of being a coordinator, I've seen that Mary Elizabeth and I get these back and forths wherever they're coming from the county, where we get copied on it, and she and I will know, no, this is an employee matter, no, this is not an employee matter. If it's an employee matter, it is going to Mary Elizabeth Osterman, who is, as you know, is the director of our Office of Equal Employment Opportunities. If it's not an employee, if it's a member of the public, does not have to be a resident, anyone traversing through the county of Nassau onto county property, encountering a county employee that feels they were discriminated in some way, that's going to start with being deferred to me. And the complaints come in from everywhere. I mean, look, the county executive's office, that's their elected official, so it's not unusual that the first call that someone who thinks that they've been wrong, they're going to call Bruce Blakeman's office. And then before you know it, it's getting steered across to the right direction. As far as the complaint goes, one thing that I do want to, a couple of things I want to point out on it. First of all is that the forms are on the website. They currently are PDF fillable. The next process that I know IT is working on is that they will also be HTML enabled for the purposes of those who are sight impaired. But it may not be. It may come to me through a phone call. It may come to me through an email. You might, in your own department, have had someone fill out the form. So that's the first course of action. The next thing is that I'll notify the department head and their assigned rep, which is why having the right assigned reps and letting them know, and why you're being trained today, so that I have an active list, because I'm sharing that active list with Brian and Matt, and if a resolution has to be done, when we get the complaint form, we have to contact your rep as well as the department head to say, we want you to know that a complaint has been filed. We don't want it bouncing around, because for two reasons that I consider of utmost importance. We want to take discretion here. Discretion is very important for two reasons. Is we have a member of the public who feels that they have been wronged, and they have the right to have a fair investigation. We also have an employee of this county, a coworker, who it has been alleged to have committed a wrong against that member of the public. So discretion is important. Keeping our department reps list up to date is important. We don't want it being, we don't want ping pong going back and forth over emails as to who's handling this, because then all of a sudden, it's 10 emails later and 20 people have seen something that maybe not everybody should have seen. We want to do that. We want to make sure we handle this with the utmost integrity. The investigator needs and has to have a fair investigation. We want to make sure that the employee as well as the person from the public get a fair investigation based on the complaint. So the next thing is that I'll notify the department head and the department rep, as I said, that a complaint will be filed, and then a county investigator will be brought in. And will do their magic as far as investigating all aspects of it. That doesn't mean that you're not already looking into whether you think something was wrong or not. That doesn't mean that you're not already looking into whether there needs to be some remediation. You're looking at it, you're aware of it. If you're the department rep or your department head, you're already trying to ascertain some information. But the county investigator will come in and do all of the neutral work as far as interviewing the persons and the complainants, interviewing everybody in the department related to the situation, and then making a determination. So again, I'm just going to reemphasize, it's not water cooler or lunchroom conversation, and please, by all means, it's not for dissemination on emails to coworkers about what may or may not have happened in your department. It's all about protecting the employee. It's all about protecting the public. It's all about, bottom line, our federal financial assistance and staying in compliance with it. Regardless of whether the investigator determines that there's non-compliance or not, your department heads, you and your assigned rep will be notified that as to the determination. And we also have a copy of that notice that goes out to the complainant to let them know of what the determination was. Once the department head and rep receive the notification as to what was determined, you have 10 days to respond as to whether or not you're taking action and what remedial action was taken.
I was just going to address some of the typical complaints that come up with reference to language access, and given the resources we have now, it's very simple to either avoid some of these, or they fall into two basic buckets. The first is whether or not the county employee made a good faith effort to comply with the language access plan. And given our resources, given the language line contract, there's really no reason to have a problem with that sort of complaint. The second is complaints about the quality of the interpretation itself. That you're not going to have a lot of control over. That's going to come down to the person's satisfaction with the interpreter. So I'll just go through. So the first type of complaint, I was not offered an interpreter. Now there's no reason not to at least offer an interpretation service if it seems apparent that someone is in need of it. Second, I asked for an interpreter and was denied. There's no reason to deny someone an interpretation. You can make the call. You can see if there's an interpreter available. You've made your effort to comply with the language access plan. Now, then someone might complain about whether or not the interpreter's skills were sufficient. Again, with language line or even a certified interpreter that is a county employee, if someone's certified, if they're a certified interpreter, their skills are sufficient. They've been deemed sufficient. But you can't anticipate a specific member of the public being dissatisfied. So we have to allow them the means to complain about that. It doesn't mean that the complaint's going to be valid or held up. The interpreter made rude or inappropriate comments. Now, that's going to come down to the specific interaction. There's nothing you can do to prevent that. I highly doubt it's going to actually happen when working with a certified interpreter. But again, these are complaints that come in. I waited too long for an interpreter. As I spoke about before, I have not seen a long wait for interpreters being a problem now that we have language line on call. And if it is ever an issue, it's only going to become an issue if you're searching for an interpreter of an extremely specific type of language or dialect, something that is not often an issue when dealing with a member of the public in Nassau County, a language that is not spoken by a significant percentage of the population. And in such a case, it's going to come down to a reasonableness standard. They may have had to wait an hour to get an interpreter for their specific language, but given that language, that may have been a reasonable wait. And finally, I was not given forms or notices in a language that I can understand. Again, Language Line now provides document translation services, so we were able to respond to these types of complaints. These may come down to, once again, a speed or efficiency issue, but again, that's going to be the reasonableness of the particular situation. Anything further?
Give me more. Title II is a very complex document with regard to what the county must do to ensure compliance with the law. With regard to the conflict resolution form that we have up on our website, it's very important that all of you take back to your staff, your frontline staff, your back of the house staff, what the process is for filing a complaint. The answer is not, oh, call the office for the physically challenged. Not how it works. If it's going to work correctly, each department or the rep for that department will take the complaint and the information, log it, send it over to us, and then we can proceed with an investigation. We may have more questions, inevitably, But we need to know a little bit about the situation, what may have caused the situation, and also if the department has already taken steps to resolve the conflict. Just don't say, call the OPC. We get a lot of those phone calls, and it just creates more work back and forth. So, very important. While you're alerting your staff to the process for all three of these issues, if you're aware, or if they're aware of a non-compliance situation, whether it be language access, Title VI, or Title II, bring it to a supervisor's attention. Don't let it just sit there, you know, like I got a secret. Doesn't do anybody any good. At the end of the day, it's going to bite us. Compliance is a very important part of it. It is incredibly challenging, and you could ask Parks and DPW of the challenge they face with compliance. There's budget issues, there's all planning issues, there are delays because of budget and planning issues. Our objective is to eventually be 100% compliant with the law. That's going to take a while. We are in the process. I know how hard both Parks and DPW work to bring us into compliance, but it is a challenge, and we don't always know everything that isn't working properly. So if you're aware of something, bring it to our attention. Very important that you have your staff follow the guidelines. Don't just, you know, make a phone call and say, hey, there's a problem over here. Get the information, fill out the form, send it over to us. It'll make our job a lot more efficient and productive, and again, conflict resolution, not complaints, conflict resolution.
Just to add to that, compliance review is a big part of it. So if what I can't emphasize enough what Matt said, he said it so well. Any information that's coming directly into it, you do have to speak to your front lines. You do have to speak to your employees, and they have to feel the communications open to come to their supervisors and tell them what's going on. And you should make a record of it, because when the investigators are coming and asking questions, if there was an incident or what looked like it could be an incident, and you've taken care of it, that makes the investigation that much easier. That keeps the intake and the determination much easier and much more smoothly, to show that a department tried the remediation immediately.
The last thing we just want to go over is Equal Employment Opportunity Plan. And this is really to remind everybody that if a county employee, not the public, but a county employee has experienced any form of discrimination, harassment, and or retaliation, it can be by a coworker, by their boss, by a member of the public, or by anyone. They may file a complaint under the Nassau County EEO policy. The complaint may be filed with your departmental EEO representative and or with the Nassau County EEO Director, Mary Elizabeth Osterman. A copy of the policy can be found on the county website. Complaints of county employment discrimination may also be filed with, and I have on page 29 of your page, it's the New York State Division of Human Rights, their address and their website, and or the EEOC district area and field offices can also be filed in person, and or we have their website. They fill out a form online and they're protected. That's when I usually get involved. So if you're hearing from me, it's because somebody has filed a complaint against you. Also be advised that the New York State also has a free and confidential hotline for anybody to connect with pro bono attorneys for the limited legal advice on sexual harassment. This is a program that our governor has put into place to stress that to try to eliminate sexual harassment in the workplace. and there is a specific hotline for that, and that's also listed on page 29 of your book. Anybody else has any other questions? The legal statutes that we did are located, I believe, on pages 30 and 31.
And 32. 32 is where you have, the last page is where you have our contact information, and you also have the link to the website on the county website. They now have it, we drove PR and IT crazy, and they have it now that pretty much you put in so many different keywords, and you're going to go right to that page that has the public notice and that has the 3 forms depending on Title VI, Title II, and ADA. So that's on the last page.
Let me just point out too, that public notice is not an optional thing. It has to be posted.
Okay, so that is the public notice. Please, when you go back, make sure your department and your building has all those beautiful notices on it. And thank you very much for attending today. And Mary, did you want to say anything?
We're 3 minutes short. You're not gonna get that.
Yeah, just thank you everyone for coming. Terrific job, Sue, Irene, Brian, Matt. Really a lot of work, great information. Everyone, please make sure, attorneys, you sign out. Don't forget to do that if you want CLE credit. Hand in your evaluation forms. And if anybody didn't get the material today, let me know and I'll send it to you. It was emailed. Take care.
God help us. Yeah, that's pretty damn short, a little short supply of that these days, but you're right. That's really what
I'll take the evaluation forms if you want to hand them over.
They're communicating. Not a skilled interpreter. The communication is.